Hi, everybody. My name is Aaron Burke. I'm a partner at Fee Smith here in Dallas. I'm actually not in Dallas right now, but we're doing everything Zoom and virtual these days. We appreciate everyone joining in for this CLE on dispositive motions, and we thank the Dallas Association of Young Lawyers and Sherry Harris very much for organizing and keeping us kind of on task here. So I'm going to start off by just introducing the panelists. I'm going to have them introduce themselves, give us their names, their law firm that they work at, and also describe their practice area, and then we'll get kicked off on the dispositive motion CLE. So why don't we start with the newest vintage of our group, Tanika Brown. Tanika, why don't you introduce yourself and give that information, please?
All righty. Good afternoon, guys. My name, like Aaron said, is Tanika Brown. I am currently with McDonald Devon, and my practice area includes insurance defense and some commercial litigation.
Okay, and next, let's get Drew. Drew, could you introduce yourself for us?
Yeah, hi, I'm Drew Spaniel. I am with Howard and Spaniel, PLLC. After about 15 years in big law, a buddy of mine and I started our own practice. We do primarily commercial litigation with my emphasis being in financial services, but I've handled employment matters, employment discrimination, non-competes, a lot of various things. Just over the years, that's kind of what happens in litigation.
Okay, and Karan Wright, would you introduce yourself?
Hi, everybody. My name is Karan Wright.
Please.
I'm an attorney at Wright Legal Services. Just recently started my solo practice. I spent a number of years working in some large firms in town and out of state. And my practice now primarily focuses on commercial litigation, construction litigation, and the occasional employment dispute, and some counseling advice for a majority of my clients.
Thank you, Karan. And I mentioned it at first. My name's Aaron Burke at Fee Smith. My practice area is primarily commercial litigation, and from plaintiff and defense side, products liability, and then every once in a while I'll take either a personal injury plaintiff side or a big commercial plaintiff side on contingent. So let's get started. One of the reasons why we decided to put this panel together is because I think Drew, Karan, and I can speak for us, we're kind of the gray hairs of the bunch here, and Tanika is a newer lawyer, but one of the things that we found that young lawyers can really make themselves just instrumental for their firms doing is the dispositive motion practice. It's no secret that fewer and fewer cases go to trial these days. And so the motion practice has become even more important. And whether you're in state court in the Valley or, name your jurisdiction, or federal court, it's important to really get just kind of a belt and suspenders approach to your dispositive motions. And that goes from start to finish. And that's what I've asked the panelists to join me today to discuss. The first thing I think we ought to talk about just briefly, and I'm going to pass this off to Karan, is Karan, what kind of, from your view, is a dispositive motion? Maybe we'll start with just the ABCs.
Sure. So, dispositive motions are those that will resolve any cause of action in the case. So typically in federal court, you'll see those at the motion to dismiss stage where you have a Rule 12B motion or of the sort. In state court, we do have motion to dismiss, and I think one of the panelists here will get into that in a little bit more detail, but we usually don't see those in state court because of some of the risks associated. The next kind of dispositive motion are usually summary judgment, where you're getting any particular claims dismissed or the entire lawsuit dismissed. And then finally, there are J&OV motions or directed motions that occur later on and during trial. So dispositive means we're getting rid of either a party's claim or defense. It could be the entire case. It could just be one cause of action. It could just be one affirmative defense.
Thanks, Ron. So one of the things that we wanted to discuss, you know, the panel here today has got a varying background from both plaintiff side to defense side. And, you know, this isn't a defense only. You know, I think a lot of times we think of dispositive motions to be primarily a defense side mechanism, or at least I have kind of throughout my practice. But I think that I've heard of plaintiffs using it effectively. Drew, do you have any thoughts on kind of just when you start out in litigation, whether you're on the plaintiff side or the defense side, just what do you do when you're looking out for, is this case one that's a correct type of case for dispositive motion, or what do I need to do even on the plaintiff side or someone responding to a dispositive motion, whether you're plaintiff or defense?
Well, I think you hit the nail on the head. It is largely a defense practice. Certainly at the motion to dismiss stage, it is. And there, some of the simple things you want to look at, it's almost like a law school exam, in that you want to look, are all of the elements pleaded? If they didn't plead, you know, if it's a negligence case and they didn't plead that you have a duty to do it, then it's ripe for a 12B6. I mean, or in state court for a 91A, that's just a flat out failure to state a cause of action. One of the things you want to look at on the defense side is, are you moving to get rid of that action entirely, or are you moving to essentially get them to replead? Because both in federal court and in state court, your first shot is free, right? You'll get an opportunity to replead whatever action it is as a plaintiff. On the plaintiff side, you know, you're usually not going to move for a dispositive ruling until at least some discovery has been done, because as Karan mentioned earlier, you're going to, in that case, be probably moving for summary judgment to knock out some affirmative defenses. It's very, very rare, I think, to move for summary judgment on your own causes of action. Occasionally, you'll see people do it just for leverage, which these days actually is becoming more and more important because, as Aaron mentioned, fewer and fewer cases go to trial. So sometimes just for leverage purposes, you want to have a motion for summary judgment sitting out there. But I think for the most part, you want to make sure early on as a defendant that you are either knocking out some or all of the claims just simply based on either a lack of evidence or a lack of for a particular element. And, you know, if you can, as a defendant, you'd like to move for summary judgment on all causes, even ones that you kind of don't think will necessarily get knocked out, just because those are fewer issues for trial.
Okay, thanks, Drew. Tanika, do you have anything to add kind of from your perspective? I know you're involved in drafting summary judgments and arguing some of them. Any thoughts on that? Just stages of the case, you know, you just learn about the case from either your client or your supervising attorney. What are you thinking as far as, or as it relates to dispositive motions, Tanika?
I'm thinking about the facts. I'm thinking about, okay, which facts do we have? Which facts are good for dispositive motions? Which facts are bad? And which facts do we need to support it? So initially, I'm pretty much ahead of the deadlines that we'll have and what court we're in and what judge we're in front of, because whether it's state or federal, because all of those things are important. And when I bring this argument or bring the position to the supervising attorney, I need to let them know the goods and bads. And, you know, of course, my job is to be the master of the facts, so that way we can come up with an analysis and strategy together.
Okay, thank you. I think that we've touched on just from a 30,000 foot view, dealing with the dispositive motions. And Tanika, I'm going to hand this back over to you. What about just default motions. You know, I know this may not be something that you've had a ton of practice area in, but you know, what is something that you think about or what you're doing when dealing with default motions? Some advice to the attendees we have today.
Like if I'm filing a default, if there's one I get seen.
Either, but if you, yeah.
Either, but what? I'm sorry.
Either side. From the defense side, if let's say you get a case and they've already, you know, your client was late, they didn't answer, and they filed default, what do you do?
Right. Well, so that's going to take some going back and figuring out, okay, the pieces of what happened before I got that case, and then going back to knowing what court you're in and what judge you're in front of. Most times, the judges understand that, and they will go back and say, okay, well then, you know, this happened before you even got onto the case or before you guys even had an opportunity to file the answer. And so you're just kind of looking at where you are, what was filed and why. And a lot of times, not a lot of times, sometimes the client, you know, they didn't know before they got it to you, or things happen in the process, but like sometimes there are things on our end that we could be more mindful of, like those deadlines, checking the court, local rules, things like that. So I think if there's a default judgment, sometimes I've seen where sometimes they are, it's a mistake, you know, or sometimes it just kind of happened and, you know, you don't know why because you didn't have it at that time. But yeah, I think that you just kind of look at where you are and what you need to do moving forward.
Okay. All right. Let's kind of segue a little bit into summary judgments. I know Karan had a small treatise on summary judgments that he shared with the panelists here. Karan, what are your thoughts on, well, first of all, you want to give us just kind of the two different ones? I know for some of our attendees, this may be a little too basic, but for some, you know, if you're a brand new lawyer and still wet behind the ears, hearing some of these things may be useful. So ignore it if you've done a lot of these things. But Karan, why don't you give us just kind of the two different summary judgments, sure, and then what we ought to be looking for as young lawyers when we're dealing with those items.
Sure. So under the Texas rules, you've got an opportunity to file a no evidence motion for summary judgment. And then you've got an opportunity to file what we call a substantive or traditional motion for summary judgment. And so the difference is in a no evidence motion, you are, as a party, filing a pleading that essentially says the other side has failed to provide any evidence to support any elements of their claim. So what that looks like from a defense standpoint is, let's say we've got a breach of contract claim. I'm defending a party in that claim. And part of the allegation is, you know, there's a contract, my client breached, their client suffered damage. We've deduced some evidence and we're getting close to the close of discovery. And we have yet to get any evidence on what the damage was, what damage was caused by this alleged breach. At that point, my client has an opportunity to file a no evidence motion and simply say, hey, one of the elements required to succeed on your breach of contract claim is to show that you were damaged. There's no evidence in the record of that damage. Therefore, we're entitled to summary judgment on that claim. So that would be your basic no evidence summary judgment. And those things require, typically in Texas, you're looking at ensuring that there was adequate time for discovery, that you know, there are no outstanding discovery disputes, and items like that that would allow the court to say, wait a minute, the party still has an opportunity to identify evidence to object to that motion. So those are kind of, those are motions, typically we see those, they're filed kind of right along with a substantive motion. On the substantive side, what the parties are doing there are identifying the facts that are undisputed. And how that comes up is, you know, in deposition testimony and transcripts and affidavits. And based on those undisputed facts and the application of what the legal standards are there any real factual disputes? And so that's what we're doing at the substantive stage as opposed to the no evidence motion. One of the things that a party should be looking at as far as when we're dealing with a substantive motion for summary judgment is ensuring that we are gathering the right evidence as we are proceeding. Because when we get to the close of discovery and we do not have the right evidence to support or defend against a motion for summary judgment, we are putting ourselves in a position to potentially lose the case, to potentially get the case dismissed in a dispositive motion. So it's important that we are identifying what evidence is going to be important, what evidence might create a fact issue, and deducing that evidence either in depositions, discovery, written discovery, or even from third parties as whatever we need.
Good, good. All right. Thank you,
Question?
Karan, for kind of that breakdown. Yeah, it did. It did. Yeah, I appreciate it. All right. So, Drew, let's talk a little bit about, we've got the standards. We have the two types of summary judgments. What are some concerns or pitfalls, so to speak, that you've seen in practice in just the summary judgment arena, whether it's no evidence or traditional?
Karan hit on one of the big ones, and that is making sure that you have, for a traditional summary judgment or to avoid a no evidence summary judgment, is to make sure that you have the evidence to support whatever claim or defense you are moving for summary judgment on. And one of the big things to do, and Tanika kind of hit on this when she was talking earlier, is, generally speaking, at the outset, what you'd like to do, especially if you're part of a team on litigation, is you literally want to sit down and kind of create a claims chart or a defense chart and say, okay, here's the claim, here are the elements, what do we need to either prove or disprove that? And that chart may change throughout the course of litigation, especially in terms of the evidence that you're trying to collect or defend against. But that's one of the best ways to both move for either a motion to dismiss 12B or 91A, because again, if you just notice that some of these things are missing from the initial pleading, that's a great way to just start out with that. And then that's a good kind of roadmap for your litigation, because again, you kind of want to be filling that in as you're going along. One of the other things that I wanted to hit before we move along is at the motion to dismiss stage, which is very early in the litigation, as a young associate, and even for the partners on the file, it's important to remember that that's likely the very first pleading that you're going to be filing, certainly on the defense side. So the fact that you can file something like that doesn't mean you should. And what I mean by that is, if you're just going to file some kind of rote, perfunctory, going through the motion, don't do that. And, if you're a young attorney, I'd kind of counsel you to talk with your partners about it, because you are effectively just wasting the court's time. And that's never something that you want to be accused of, especially by the court. And, as a young attorney, that may be your opportunity to argue in front of the court, because some of the judges, like Judge Lynn here in the Northern District, has a rule that if you've been practicing, I think it's less than 5 years, she'll give you a hearing on things that she wouldn't give more seasoned lawyers. But you do not want to be in front of Judge Lynn and have her say, why are you here? You're wasting my time. Because anytime a judge says that to you, it's really, really uncomfortable. So I would just kind of counsel young attorneys to think that, to bear that in mind when you're at the motion to dismiss stage. Or
I think that would go for each stage. And also I've seen this as well, just I've had a prerequisite over the years, but you'll see where no evidence, some judgments are filed, and I caution that just because you can file it doesn't mean you do it. And then also, a targeted no evidence, I think, goes a long way. You only need to knock out one of the claims. You only need to knock out one of the elements to knock out one one of those claims, it will take you much more serious. You've actually one strongest area of every single cause of action, just because you feel like it's better to do that for your appellate record. But if you really want to win in a trial court, sometimes that's more effective. All right, I want to set Texas 91A motion to dismiss a little bit more here in a minute, as well as the 12B motions to dismiss. I want to go back just a little bit and hand this off to Tanika. Tanika, when it comes to summary judgment deadlines, do you have any advice for our attendees and frankly, for even those of us on the panel with you?
Be on top of them. Because at the end of the day, when it comes back, if there's something wrong or a deadline that you miss, it won't be on the paralegal, it won't be on the legal assistant, it's gonna be on the associate that's working the file. So when it comes to the deadlines, I think it's really important to, especially if let's say it's like common practice for you guys, if you get this kind of case, you guys are gonna do a motion for summary judgment. Some clients, request that you do. Some of the bigger clients do. And so with that said, once you get that case, you're gonna file one, so start on it earlier. Make sure that you request your hearing date within the right time that the court would like for that to happen. Make sure you get it on the calendar. Make sure that the calendar is accurate, because what'll happen is that, this is, of course, no one wants their time wasted. So if you could have worked weeks, because that's how long it takes to draft this motion. It's perfect. It's your baby. It's your child. It's the best thing that you've written at this point in your career, and it won't get hurt because you've missed the deadline to set your hearing and things like that. So I think it's just super, super important, because maybe I feel like this because I've almost been there. Make sure you don't procrastinate. If you know what's happening, prepare it, and then also anticipate having to file that response, because I believe it's 7 days. It comes quick. So if you're going to file it, make sure you go ahead and start your skeleton of your response. Make sure you have that stuff so that when it's time, you're already gonna be nervous, but so that you don't feel that extra pressure of, okay, well, time is the issue as to why I can't, pump this work out. So that's just my 2 cents there.
Good. And has anyone else on the panel dealt with the local rules for having your hearings on summary judgment set and heard by a deadline? Anyone want to chime in there?
Yeah, so Aaron, let me chime in. I think, so the deadlines, the way that Texas has the rules set up, you've got a timeline to file your motion, set it for a hearing, and then that hearing date provides the response deadline, and in rare cases, your reply deadline. So, using those deadlines as a strategic tool is also important, right? Because if party on the other side, if you're able to put together a motion in a fashion that's going to be substantive and significant, and then set a hearing in a shorter time period, you've now compressed the time that the other side may have to respond. So you want to think through these things strategically about when you want to file. Now, of course, some courts, some judges, instead of giving you a deadline to file a dispositive motion, you've got a deadline to have a dispositive motion heard. Now, that makes this deadline fluid, right? Now you're dealing with, now I've got to ensure that there's time on the docket. I've got to find a right date that I'm available, that opposing counsel is available. And so you're dealing with a lot more moving parts when you're dealing with a deadline about a time to have a motion heard. And so that can make it more difficult to get your motion ready and get a hearing set, and then also ensure that you're providing the kind of the response time required under the rules for the other side. So that's something to be aware of.
Thanks, Ron.
I'd say too, I'd add in.
That's one thing that I don't think. Oh, go ahead, Drew. Go ahead.
That it's particularly important in that context to think about where your case is pending, because in the bigger cities, or like Dallas or Houston, San Antonio, they're going to have designated civil courts. But in a lot of the other counties, the neighboring counties, even a place like Collin County, which is pretty big and pretty sophisticated, they have courts of general jurisdiction. So those cases are, those judges are also hearing family court cases and things like that, which have a ton of hearings, which means it can be a lot harder to get a hearing in front of that judge than in front of, a judge in Houston or Dallas.
One area, just to kind of dovetail with what y'all said, I have noticed, just especially in Dallas and Houston, and I should have probably known this just by intuition, but during holiday seasons, especially once you're getting close to the end of the year with Christmas and New Year's, typically you've got to go out 60, 90, even more days with a summary judgment or some other dispositive motion to get a hearing in time for the court schedule. And I won't call any specific judges out on this, but there are some Dallas judges and Houston judges that I've been in front of that thankfully I've not been in this situation, but where the judges, the attorneys have tried to set a summary judgment hearing before the new year. They've, got a summary judgment on file, which only usually requires 21 days notice, but the judge doesn't have anything available for 45 days. And, counsel thinks they filed it timely and with plenty of time to get a hearing. And the court has said, well, I'm sorry, you didn't comply with the local rule. And oftentimes the most vexing part of that is that some courts won't give you a hearing date until you filed the motion. And that can be very frustrating. As young attorneys, that's one thing that you can certainly be calling the court and coordinators about and asking them, and getting ready, figuring out what that court does and how busy that schedule is. But you need to be doing it, in my opinion, at least 90 days out. That way you don't shortchange yourself and you have a great motion, like Tanika was saying, one of your best ever, and it never gets heard because the court says, sorry, you didn't comply with the local rules. I don't need to, or I'm not going to have that heard. And also you may have a very ticked off client if the court's refusing to hear the summary judgment because of not following the rules.
So I did want to add something.
So I'd like to, yeah, sure.
Yeah, I just want to add that really pay attention to the scheduling orders that you get in from plaintiff's counsel, or depending on whatever side you're on, because like you were talking about, Aaron, with those holidays and what court you're in and certain judges, it's like you really got to start paying attention to that type of stuff from the outset of the case so that you can put yourself in the best positions to where, and when it's time, you can actually get your motion heard. So that's all, just the scheduling order piece too.
Absolutely. Thank you, Tanika.
Mm-hmm.
All right, so what I'd like to talk just briefly about, we've heard a few times about the 91A motion. I have always been very hesitant to file it for defense. Obviously, it's a defense motion, but from defense perspective, recently there was a change to the law that Andrew reminded me about. And so, Drew, I'd like you to would you tell us about the 91A? Tell it to me like I don't even know what one is, and then explain kind of some of the timing issues with it, and also that fees question that we visited about.
Yeah, a few years ago, the Texas rules were amended to allow for motions to dismiss because prior to that, kind of surprisingly, it was a vehicle that didn't exist in Texas civil procedure. 91A is modeled largely on 12b6, and the comments tell you that it is intended to be a corollary to Federal Rule 12b6. But importantly, initially, 91A had a loser pays provision in it, which was to say, if you filed a motion to dismiss under Texas Rule 91A and you lost, it was mandatory for the court to assess you fees on that. It was supposedly the amount of fees that the other side, the prevailing side, had spent in fighting that motion to dismiss. And as Aaron said, that was a big deterrent to filing motions to dismiss in state court, because no client wanted to take a chance on filing one and getting popped with that, because as I think everyone here knows, even very young attorneys, in a motion to dismiss, everything is interpreted to be the most favorable to the non-moving party. So basically, unless there was just a glaring error in the way something was pleaded, you couldn't count on winning. You couldn't count on winning any portion of it. But last year, almost exactly a year ago, that rule was amended to make it discretionary for the court to award fees. And again, the comments were pretty explicit to say this amendment was intended to encourage, or at least to not prevent defendants from moving for dismissal, because again, if you have a good motion to dismiss, you are making the court's life easier. You are because you are knocking out claims. And I would say kind of just a good general rule for litigation, whether it's scheduling or anything else, is ask yourself, am I doing something that will make the court's life easier or harder? Because if the answer is I'm going to make the court's life easier, the court is much more inclined to help you on that. If it's whatever I'm going to be doing right now is going to make the court's life harder, you are not making a friend with the judge. And with regard to motions to dismiss, again, while I think the rule change was intended to give parties a little bit more, defendants especially, a little bit more comfort in filing motions to dismiss, it's certainly not something that you want to do frivolously.
Okay, Karan, do you have anything else to add on the B1A motions?
So I think on, motions to dismiss, Drew touched on this earlier. It's one of your first opportunities to present to the court your position, your client's position on the petition or complaint. And so when you're putting that together, you want to make sure you're not lumping in kind of all the frivolous things that go along with your motion with the good stuff. Because if you've got a great argument why a particular cause should be dismissed, you want to make that argument, but you don't also want to throw in the frivolous argument that these other causes of action should be dismissed, because I think it takes away from the credibility of your argument on the other motions. And then it also, in the later part, when you're looking at filing a motion for summary judgment, you've already lost some credibility with the court because you presented the court with a motion that was somewhat or borderline frivolous on certain claims. So, and that goes for summary judgment. I think some judges will respect a movement who files a motion for summary judgment and is not seeking to get rid of the entire case. I think there's some additional credibility to the idea that, look, these particular claims fail, and this is why. We're going to narrow them for trial, and Your Honor, these are the only claims that should remain after this dispositive motion. I think that lends some credibility to a motion, especially when you've got a good understanding and you know that you're not going to be successful on identifying or showing that there's no factual issues. So that's kind of my take on that, and I think that bodes. That's good advice, I think, for state court, but even more so for federal courts, where you're not having an opportunity to go in and argue your motions orally.
Thanks, Ron. A couple things that I wanted to add that you reminded me for the summary judgment thing, that I don't know how much they're teaching us in law schools these days, but one thing that I've seen time and again from younger attorneys who are working on some of my cases is the desire to combine the no evidence motion with the traditional summary judgment motion into one document. And this is just a tip to just based on several cases that have come out over the last even 10 years. If you combine a traditional summary judgment, like Karan explained earlier, where you need substantive evidence, either depositions, transcripts, those kinds of things, with your no evidence in the exact same document, then even if the other side does not respond at all, they can, let's say they blow their deadline and they don't respond, they show up to the hearing, they can use the evidence that you attach to the traditional summary judgment to defeat both your motions, both your no evidence, which you told the judge there's no evidence of. They can use that evidence and point to, for example, let's say you get overzealous, or paralegal or someone else gets overzealous and puts a whole deposition transcript and attaches it to the summary judgment, the dual summary judgment motion. They could then go point to the transcript page and line where they think they create a fact question and can beat you with your own summary judgment. So I've seen that over and over and over. I would suggest it's probably borderline malpractice, so don't do it. So that you can take that tip to the bank. Does anyone have any kind of advice? And I've gotten various degrees of advice, and it kind of, in my experience, depends on the type of attorney I've dealt with over the years. But does anyone on the panel have any thoughts on whether you go for the kill and kick a person while they're down and get that award of costs or that award of fees? And are there situations where you think it's appropriate to really go after the fees and costs, or are there situations where you might caution your client against it, and why? Does anyone want to try to take that question on?
I'll take a little bit of a shot at it. Certainly on
Sure.
91A or 12B6 on the motions to dismiss, I think that it's important to remember you're unlikely to get entirely out of the case on that. So, just sort of gauge the relationship that you want to have with that attorney and that opponent for the next year, 2 years, however long it's going to be, because you're very much setting the tone for that. On motions for summary judgment, I think, it very much depends on what your cause of action is, right? I mean, if it's a breach of contract that has, and the contract has a loser pays provision, I think you're kind of, I hate to say foolish not to seek it, but I mean, that was a negotiated provision. So, I would absolutely move for it. And, with motions for summary judgment, you are generally much further down the line. So there's been a lot more work that's put into it. The tone has already been set. And I think courts are much more willing to, or will probably be much more open to awarding fees in that regard. And I will say, at least once, even under 91A, when it was when at least ostensibly it was a loser pays provision there and fees were supposed to be mandatory, a judge just told me, I'm not awarding fees on this. I know I'm supposed to. You can mandamus me if you want. And I will tell you, when a court lays that down on you, don't mandamus them. That's just really, if you think you've made a bad decision in ticking off your opposing counsel, you're making a really, really bad decision in ticking off your trial court judge.
Okay, anyone else have thoughts on that topic with fees and costs and how to address it?
Sure. So Aaron, one of the things, I think that's important. I mean, especially in context of Rule 91 and fees, you're early in the case. And so you don't want to go about, one, making frivolous arguments as the party moving for dismissal. But on the other side, you also don't want to be a defendant responding to a motion to dismiss and making a frivolous argument that the motion to dismiss wasn't itself frivolous, right? I mean, you're you're toting the line there by asking the judge to award you fees under Rule 91, and your argument is essentially going to be that this motion was frivolous. And you know, I'm speaking in circles, but if you can follow your frivolous motion asking for fees, suggesting that another motion is frivolous is, you know, that's going to put you in a bad spot too. You know, there are many times where a motion to dismiss are sometimes frivolous, but I think in general, you know, there are at least some grounds for a good faith motion, even if it's strategic, and even if it's you know, something your client's directing you to do. I know in federal court, you don't necessarily have that provision to kind of seek cost. You know, that's kind of entirely up to the judge's discretion there, and a judge will tell you if he or she thinks the motion to dismiss is frivolous. That'll be something that's in the order, and at that point, you'll have some basis to move or request that certain fees be paid. But you know, until then, I think you kind of take it as you go and look to put your best foot forward at a later stage, especially when the arguments aren't completely in bad faith.
Okay, thanks. One small thing I'd add about the costs and fees, especially like you know, Andrew had said, it sets the stage on the motion to dismiss. Well, with summary judgments, one thing that in practice I've certainly tried to be good about is if I think I just have a slam dunk argument, I'll talk to the attorney on the other side, and I'll say, look, I would prefer not to have to file this motion, but if I do, I'm going to have to ask for costs to offset my client's cost and having me have to go do this. And so sometimes, you know, sometimes the other side, especially if I have a good relationship with the other attorney or we've kind of developed a rapport, they'll recognize that, and they'll go to their client and say, here's the risk. He's telling us that his client's going to insist on a cost, and you know, this case has been going on 2 years, and we got $25,000 in court costs or whatever the case may be. And I've found that can be persuasive, but you know, you always have to think. And it's a huge legal community, but really it's very small. And so, you know, one thing that I was taught as a baby lawyer is what's good for the goose is good for the gander. So if you go down and if you win and then you spike the ball and then you try to be punitive about it, sometimes it can come back full fold and bite you in the butt, either by virtue of an appeal or the next case you have with that attorney or that opponent on the other side. So just something additional to think about while you're going through that dispositive motion practice. All right, so we covered summary judgments, we covered defaults briefly, we covered 91As. I want to talk just generally about special appearances. Special appearances, and we'll just if we can for the panelists, hit on 12B motions while we are, because we're kind of running out of time here, because 12B also has a special appearance. So anyone here want to take on, what is a special appearance? What are you thinking whenever you're getting ready to file one, and when does it happen?
I'll take a stab at the beginning of it. A special appearance in state court is akin to another 12B motion. You're challenging personal jurisdiction. It's usually, certainly in the commercial context, it's saying I don't have any or I don't have the requisite minimum contacts with this jurisdiction for this court to be able to call me in and to preside over whatever cause of action is going on. Things to think about before you do that, obviously, are, do you actually have, or does your client actually have those contacts? When I have run into it, it is frequently an individual who is named in connection with a company that's being sued, because the argument is generally, yeah, the company does business here, but that individual doesn't have any specific contacts here. A few things to think about, in addition to the just I don't have those contacts, is if you make a special appearance, there will be an evidentiary hearing on that. And for younger lawyers here, that means that there will likely be live testimony. You're going to have to actually enter evidence. It won't just be affidavits or verifications. And almost assuredly, the court is going to allow jurisdictional discovery, which is to say, it won't necessarily, it won't be about the merits of the case, but there will be a period of discovery just to find out whether this person has any minimum contacts with the state. And it doesn't have to be, and this is important, it doesn't have to be contacts that are relevant to this case, right? If the company is being sued for a particular contract or something like that, but you just fly in and out to personally shop at Neiman's, you have the requisite minimum contacts to be subject to personal jurisdiction in the court.
So I'll add to that, Aaron. I think one of the things right off the bat is you want to make sure you haven't accidentally entered an appearance.
Right.
You want to make sure that there's a petition that's been filed or a complaint, and you've reviewed that with your client within that time frame to file your answer, and that this is the first pleading you put before the court. Rule 12 requires you to, before an answer is filed, you plead certain defenses, including jurisdiction and some other items. So that's very important. You don't want to just willy-nilly, have your assistant or paralegal file a entry of appearance or notice of appearance by counsel and then wait around to file the 12 motions after that. The other thing about when you're contesting jurisdiction is to be aware, or at least one of the things that I do when I initially get a complaint in is I just go back to the rules and I start from right around what are defendant's pleadings. And I go through and say, well, my pleadings are an answer or this, this, and this. And the rules will outline or give you a step-by-step way to analyze the complaint or petition to figure out what needs to be filed. So, motion to transfer venue, for instance, or a motion for lack of jurisdiction and so forth. So the rules provide those outlines, and I think it's important to go back to the rules when you are getting ready to put together a response to a complaint or petition.
Okay, Tanika, do you have anything to add? Just special appearances, what you're looking at when you get a new case in? Right.
Sometimes we get caught up with, the amount of cases that we have, but we really have to be mindful because some places the paralegal will go ahead and send out the answer or things like that. But like Karan was saying, I think it's super important to make sure you haven't already answered, already appeared in the case, because then you've missed that opportunity most times. But that was really, and when I'm looking at that, typically try to have, like, if I get the petition, I typically try to have a call with the client very, very soon after. That way, if there is something wrong with whoever's named in it, or if there is something wrong with which company, that happens a lot. The company names are just not right and things like that. We can talk that through and get that special appearance on file if necessary.
Good. Thank you, Tanika.
Mm-hmm.
As far as the special appearances go, I'm talking to people who are more freshly out of law school than me, but we do have the due order of pleading rules in Texas, and then the federal system also has that. I can't emphasize enough what Tanika just said, which is talk to your client early. I have a case in Nevada federal court right now where we've just filed some 12B motions contesting jurisdiction. As of them has several different contacts. He's traveled to the state, but the business that he's being sued for had very few contacts. And it's kind of what Drew was saying. You've got to really dig down into those facts, because you are going to have an evidentiary hearing potentially. And you're going to have to explain to the court why. Well, some of these contacts happen, but they're not enough for it to be fair to bring him or her or the company to this state's court, or to this, in many of our practices here, to a Texas court. So keep that in mind, and then don't accidentally file that original answer in state court, with general denials before you've had that analysis, because later on, people may be looking at that file and saying, well, wait a minute, this company doesn't do any business here in Texas. Why'd you answer for them? And I've actually been hired on several cases where I'm questioning the prior counsel and wondering why they answered in Texas instead of filing that special appearance. So, all right. So I think we have, and for all of our attendees here, let me tell you, DAYL, Sherry Harris is going to, at the end, post the CLE number. This is a self-report CLE number. You'll have to report it with the Texas Bar. And then she's also going to send it by email. So if you don't hang on, or you have to sign off a little early, then you will get an email with that CLE number. We are also going to take a few minutes right at the very end for any kind of questions. And once we do that, we'll use there's a participant feature up, and I'm on an iPad, but on your computer and iPad, they're similar. It's under the participants, and you can click in to raise your hand, and it'll digitally raise your hand, and I'll be able to see who has questions. And then we'll kind of pipe you over. If you want to be on video, you can be. If you just want to be on audio, you can do that as well if you have a question for any of the panelists today. Okay, so I think we've covered most of, kind of the belt and suspenders approaches to dispositive motions. There's one more. This one is much more of an enigma to me, other than just the concept of government, county courts at law in some jurisdictions in Texas have only a certain amount of jurisdiction as far as monetary damages go. But we have a panelist, Drew, who y'all can tell is a very bright guy. He's actually had quite a bit of experience dealing with pleas to the jurisdiction. And so I'm going to just ask Drew to tell us what's a plea to the jurisdiction, and kind of explain to us why is that something that still is relevant to some of our practices, and why should we be looking out for that when we're talking about dispositive motions?
A plea to the jurisdiction is a challenge to the court's subject matter jurisdiction. So instead of saying, I am not personally subject to jurisdiction, you're saying to the court, you don't have subject matter jurisdiction here. It's the instances, as Aaron mentioned, are there are pretty few instances where you can use it. One would be like ripeness or mootness, the kind of thing that lack of standing, the kind of thing that comes up on a con law exam in law school. The instance where I've seen it more often is when you're representing some entity of the state. And it's sometimes ones that you don't even think about that much. Like my wife works at UT Southwestern. They are a branch of the University of Texas. And so sovereign immunity, which is a defense that you would use a plea to the jurisdiction for, is one that comes up for them quite a bit. And it's a very powerful weapon, because essentially what you're saying is it doesn't matter whether I did all the things they said I did or not. I am immune from suit. A few things to consider when you're looking at that are obviously who your client is. And again, it's one that's going to have an evidentiary hearing at the end of it. So you do need to think about what evidence you would want to present to demonstrate that you are immune from suit. The other kind of one that came up with in my practice, because I represented banks, was that it's important to remember that a very odd quirk of Texas law is that justice courts, typically called justices of the peace, are the only ones who can issue an eviction order. And so, it has come up in my practice a couple of times where, you got a default, an order on the default and a judgment that the tenant was in default. But to go and evict, and you got that in the district court, but to evict them, you have to go to the justice court to get that eviction order. And I have seen correctly pleas to the jurisdiction in that context where they said, the district court is not the proper, it's not the proper place to get this eviction order. You have to, this has to be done in a justice court. But that's, as Aaron alluded to, it's pretty rare outside of I think the governmental or sovereign immunity context to see it. And again, unless you kind of know that you've got it, that's just not one that you're going to want to try, because you will have a court fuss at you.
The one area that I've seen it used effectively is, like I said, and I haven't checked the government code in quite a while, but many of the county courts at law in smaller Texas venues are not like the Dallas County courts at law that have an unlimited dollar figure, that you can bring $1 million claim in either district or county court. Some smaller venues where the district courts aren't busy, as the Dallas district courts are, have county courts that may be capped at 100,000, 200, 250,000. And so that's something, if you're practicing in a small county, you're not familiar, it may be one of those things that it may save you, you may kind of get a slam dunk by just checking the government code and seeing what is this court's jurisdictional, what is its jurisdictional limit. And, you certainly don't, if you're on the plaintiff side, you don't want to file there and then have that issue come up, because it's not a transfer, it's a dismissal, because it's a plea to the jurisdiction. They're saying that court doesn't have it. And so if you file close to limitations, you may actually blow your deadline. All right, so I see we just got 1 minute left here. And I want to thank the panelists for joining me. Does anyone have any questions? And if you do have questions, like I said, you can go to the participants drop down and you can raise your hand. I think that's how Sherry told me. I'll give you about just 30 seconds or so to raise your hand. It should give me a heads up if anyone has questions for any of the panelists. Okay, well, I'm not seeing anybody at this time, and it looks like we have quite a number of people who joined us today. We thank you all, and I think I can speak for all the panelists. Thank you so much for your time today. We appreciate the chance to chat with you. We're all available. You can Google us all. We've all got our firm information on that invite that was sent out from DAYL. I'm happy to take emails, phone calls at any time about any of these types of questions. I suspect other panelists are as well. So good luck in your practice. Y'all stay safe. Thanks for joining us today. And thanks to the panelists here, Karan, Tanika, and Drew. I appreciate y'all's time today as well.
Thank you.
Thanks.
Thanks.